All right, we have the details taken care of. And again, thank you so much for joining us. We have people all across the country joining us today, and we really appreciate your interest in this topic. So here you hear from. I'm on the left there, Leah Lutz. I'm the Collaboration Specialist and Training and Resources Coordinator here at the Sexual Violence Justice Institute. I can work with trainings and also work directly with SART and SMART teams here in Minnesota and across the country. So basically, I get to learn from all of you and the work that you are doing on the ground every day. We also have joining us Caroline Palmer, our staff attorney at MNCASA, who's going to explain some of the laws, rules, and regulations that are relevant to this discussion today. The Sexual Violence Justice Institute project of the Minnesota Coalition Against Sexual Assault, and we are dedicated to promoting justice for victims of sexual violence through multidisciplinary collaboration, leadership, and resources. And please go ahead and check out our website there too if you have additional questions or resources or would like to know a little bit about more what we do. So I know many of you are called SART teams. In Minnesota here we call them SMART teams, and SMART stands for Sexual Assault Multidisciplinary Action Response Teams. We have 12 of these formal teams in Minnesota that as an institute we provide direct one-on-one technical assistance and support to. We also work with teams across the country in the Salt Lake SART, Deming, New Mexico, Lafayette, Louisiana, and then also have the opportunity to work with different teams through our funded projects, which I'll explain here in just a minute, and also through the calls and things that we just take from you every day as you are embarking on this work. So our goal, our mission is really to support the responders, you who are doing the work, and also the teams and how you can team successfully. So with that said, we have a couple of different bases for our project. We have our national TA, Technical Assistant Project. We are an OVW TA provider. We do some intensive TA projects. We also have general TA to grantees. Right now we are funded for community-defined solutions or arrest grantees. So after this webinar, if you have questions and would like more information, if you fall in that category, please feel free to follow up with us. If you don't, if you're stopped or rural, we'd still like to hear from you with an email or maybe a quick phone call, and we can see if we have other resources or ways to also provide you some assistance. We are going to be having a National Institute for SART Team Leaders, which I'll explain at the end of this webinar. We're also really working to connect state-level team leaders with one another and network and share the learning, and also have a couple state-specific projects. And our goal there is really what conditions do states need to support, create, in order to create highly functioning, effective SART teams in their communities. And in Minnesota, as I said, we have that SMART-based collaboration project, which you see on the map. And we also have a special grant where we're working on enhancing connections between prosecutors and medical, and then our legal resources project, which you'll hear from Caroline in just a little bit, coordinates and works on. So today, what do we hope to accomplish? Before we get into the objectives listed on this slide, I just want to make sure that we all start on the same page with how we understand case conversations. When we use the term case conversations, we mean the informal or formal processes that teams use to discuss specific cases or the larger system response to sexual cases, and in turn how policies and protocols are or are not making a difference with those cases. I think the overall goal is to prepare you as teams or team leaders to guide the way your team thinks about case conversations and help you set up and model appropriate and effective practices if your team chooses to partake in some sort of case conversation process. Specifically today, we're going to cover first the reasons why teams discuss cases, Caroline's going to go into the rules that might shape how your team approaches these case conversations, such as victim confidentiality, safety concerns, and then we're going to share with you 3 possible approaches for your teams to consider if you decide you want to embark on this type of conversation. And finally, I guess just before we go on, we just want to make sure that we're clear that we're not promoting case conversations as something your team must do. But this webinar is really designed to simply give you the tools to recognize that the topic of case conversations frequently comes up on teams, and it can be a really challenging and difficult topic to navigate and to do it well. So in short, we just hope this webinar will give you a lens through which you can view how case conversations may be happening on your team, or other considerations your team might make when deciding whether or not to discuss case or system issues. We want to give you the overall picture here as we know it, and as we've seen it working with teams here in Minnesota and in different parts of the country. I want to take just a moment and explain the documents, the tools that are for your use. I'll explain them at different points of today's webinar as well, but you got 2 handouts in your email reminder. One's a case conversation assessment, which is really designed for you to use with your team to, 1, identify which of these 3 approaches might be fit, and to also have you think about readiness considerations before you embark on this process, or if you're already on this process, things that you might want to take a step back and consider. We also have put together a What Can We Talk About handout that you can use with your teams, and it really is just a very brief description of some of the bigger rules, regulations, and things like that that need to be paid close attention to as you're designing your process. So in order to ground us, I would like you just to take a moment and just kind of think about the experience in your community, in your team. What is happening right now? Is your team discussing those cases now? Is there a process? Was the foundation ahead of time? Are the conversations being talked about formally or informally, maybe after the meeting is done and a small group convenes and things like that? Just think about the climate right now. What are your concerns about the case conversations? Do you think it's going well? Do you think it's not going well? Are there specific issues that you see coming up that you think need to be attended to? And we hope if you do have concerns that we'll give you some ideas during this webinar on how to address it. And of course, the benefits of case conversation. A lot of good work can come out of this, a lot of good learning and decision points. And think about, has your team discussed how it will discuss cases? I think that's really, really key. You're going to hear me reiterate it a few times during this webinar today. That's really important to the foundation before you begin on this. Or if the process is not going the way that you would like it to go, if you're already there, you may want to come back to that question and think about if you discussed how you actually will discuss these cases. So let's start with kind of the beginning. Why do teams want to discuss cases? I think we found some real consistencies with teams, and I think there's a strong desire to identify and fix a problem. It might be case specific, or it can be a broader system issue. There's a strong desire to improve the response as it is happening to make a difference in that individual case and for the individual victim survivor. Evaluate your response protocol. We know so many of you have protocols in place and have worked tirelessly to get there. So is it working? Case conversations can be a good way to monitor that and to look for your team those places where you need to make adjustments. Be successful. I mean, you all work very difficult jobs, sometimes very long hours, I know. As an individual, are you a good nurse? Is the SANE system making a difference? How about the advocate, officer? I think there's just that wanting to know if what you're doing is working and making a difference. And then our bigger system issue. Do we make a difference together? Is your SART team working towards the intended goals and making a difference in the community? And what is experience for the victim? You can learn so much about your handling of different cases by looking at some of this. And it can help, again, start here. You can even use the slide with the conversations with your team and really start with why you want to even discuss the cases. So teams handle case discussions in many different ways, but generally the need to discuss cases comes from the same place. So this chart, making change, what you see here is a grid that shows various methods of making change. It compares individual case advocacy, system advocacy between agencies, and system change interagency teams. And if you can look through there, all three of these need to be happening in any community as you're working towards improving, implementing the response to sexual violence, because there are just gaps that come up. Things happen within agencies and so on. And so if you look at this, individual case advocacy could be an example. An advocate reminds the medical provider to provide options around EC, emergency contraception, in the ER. There's great pros to that. It's immediate feedback. It's specific to the individual. The drawback to the individual case advocacy as far as making long-lasting change is that it may or may not affect the lasting change. And it's usually not always transferable to others. It was a great learning for that individual person who had that advocacy. We also know there's a lot of system advocacy going on, and we think of that as agency to agency. So maybe advocacy agency known as law enforcement requesting polygraphs of victims, and what happens is the advocacy agency asked to meet with investigative supervisor. A pro to that and things like that is notice patterns. It can affect policies. It can trickle down a little bit and get to some of those structural issues that really affect the overall practice. A con on that is that direct learning is really usually limited to those two agencies involved. And then in this grid, we have the system change. And that's what we are doing with these SART teams and via the interagency teams. And this is long-lasting work where a team researches the problems, designs, trains, you evaluate, you make proposed changes, and so on. A pro to that approach, obviously, it gets to those much deeper structures, and it can really create an environment and culture in your team where you're adaptive, where you correct, where you keep learning together. And you can also create new thinking, what will work. We've seen a lot of new thinking recently, for example, on anonymous reporting protocols and different things like that. The con to this approach is it requires a long-term commitment. There's usually a heavy investment, turnover of team members, and so on. So when it gets down to the system change level, this is the work that many of you are doing on a regular basis through your collaboration already. We encourage you to think about how case conversation can be part of how that change happens. How are you going to use this process to make system change? And the purpose of this for you as team leaders and as team members is to stress the importance of the work you're doing as a team. If your team is using case conversations as a mechanism for making change, then the challenge for you is thinking how you can create the most meaningful, long-lasting change by keeping the process at the system change level versus the individual case level. Now, certainly individual case levels may be impacted by this process, but it's extremely important to find ways to take the learning to impact the whole system change whenever and however and as much as possible so that you can improve the response to that next survivor or victim that needs services. So let's talk just about here a few other possible benefits besides impacting the system change. It can also really help your team adapt to change. Knowing that you don't get it all right from the start. No team does. That's the goal of it, is to keep learning, to keep identifying challenges, to keep seeing where change needs to make. And it can really help you pinpoint areas in your response where change needs to be made. It can also pinpoint areas in your response that's going really well, and highlight that too, so that you do know what's working, what's making an impact, and maybe even enhance those things if possible. You have the learning and keeping things at the individual level. This allows for the broader impact. Agency members develop. I mean, this is a great way to be self-reflective, self-critical, and continue to work towards the shared team goal or mission. And that's why we believe spending some time on the front end helps that reflective and self-critical, rather than having this process go into the conflict and disagreement portion, which can also be managed actually. So we know the potential benefits are so huge that it's worth it to spend time up front to develop a responsible approach to the process and lay a proper foundation. If your team is currently doing case conversations, it can be beneficial to take a step back and reevaluate how the process on your team works right now and what you might want to improve in the future. So we talked about benefits, so of course we also have to touch about what could go wrong. This is what we've seen could go wrong, some possible negative effects. There could be a possible effect on the team. Conflict and disagreement on how the case should have been handled. These disagreements could pull the team apart or otherwise impact relationships that have been formed. Certain team members may feel like they're always being criticized or really critical of their efforts and so on. Effect of the victim. I know from the registration we have a mix of people from rural and urban and suburban areas, and in this process there is that potential for re-victimization, victim blaming, loss of privacy, and we know that's a significant deterrent for victims coming forward and for victim safety. We've all heard the phrase loose lips sink ships, and team members can inadvertently share too much information, or if a firm process isn't laid out, there could be a culture of just kind of freewheeling the information. What we want to do is manage how the information is shared. And you're busy. As busy responders, it can be really easy for team members to forget where they heard certain pieces of information, or whether or not it was confidential context, or if it's publicly known information. I mean, it can be easy to get into those situations. There could be effect on the case. There's a potential for information being shared that inadvertently compromises the criminal case, if there is a criminal case. And Caroline will talk about this in just a moment. And there's an effect on the suspect. Depending on how the team is talking about the case and the people involved, it is also possible that case conversations could resort to gossip or unfair profiling of a suspect, or gossip about a bad family or a bad part of town or a bad demographic, and what's feeding the team and creating that feeding community safety, or just rumors about the suspect. And there's other things that could go wrong too, and I'm sure that if you can take a little mental break here, I'm sure you can think of other things that have gone wrong or could go wrong with this process as well. So how do you lay that foundation? We think these bullet points are really, really important. So if your team is already holding case conversations or is thinking about embarking into case conversations, we want you to avoid the what could go wrong and do it well, because there are great benefits. In order to do so, that proper foundation must be laid. So this slide just outlines some of those things to keep in mind to assess a proper foundation. These things are also outlined in that take-home assessment tool that I briefly mentioned at the beginning of the webinar that we created for you. And revisit with your whole team if you would like to. Share the document at a team meeting, and it can be a great way to spark some conversation about this. And usually we found teams that have success with some sort of case conversation has a strong sense of self, a strong mission, a strong shared definition of victim-centered. They spent some time meeting beforehand and figuring out how they're going to collaborate together before embarking on this process. So what about your team philosophy or the way your team carries out the mission? When things go wrong, it can be a great way to come back to it, which I'll explain here in just a minute. And so we just hope this webinar will encourage you to have the conversation up front, because many teams consider this case conversation as the meat and potatoes of team meetings, yet they've never had a conversation about how information should be shared or learned during the case conversation. And just as importantly, how are you going to utilize this great learning that can come from this process? So as TA providers, we get the most questions on the last 2 bullet points here: which cases will be discussed and the rules that apply to case conversations. So we're just going to spend here just a little bit of time expanding on those 2 bullet points. We got rid of the beeping, yay! So, when do teams discuss cases? First, with regard to timing, we get a lot of questions on that. There probably is no right or wrong time within the life of a case to hold a case conversation. It really just depends on what your team is most interested in learning from this process. There are many different learning points when cases can be discussed. Your team must determine at what stage a discussion could be most valuable, depending on what you hope to learn or how you hope to influence the system. So again, we encourage you to figure out your learning points. What do you want to know? Have that conversation first, and then how can this process enhance the team's learning? So often we see teams assume that cases must be closed to be discussed. This isn't necessarily true. We're going to discuss later on here in the webinar options for discussing open cases as well as precautions that should be in place if that's something your team wants to do. So really at any point at which a case dies or is resolved could be a really valuable learning point. So for example, here's some different ways that we have seen teams choose to have reflections and learning on this process. You could decide to look at all or some cases that are reported, but they're never referred to a detective. You could look at all or some cases of unfounded or pended after an investigation. What is happening? Are there commonalities? Are there consistencies? All or some cases referred to the prosecutor for charging declined by prosecutors. Are there trends in what is being declined? Are there trends in what's being charged out, and so on? All are the cases resolved by a plea. For example, here in Minnesota, we know like the pretext call, the control call can be a really trigger point for plea bargains, and could that be used more often in your communities? That's just one example of learning that can happen if you choose to look at a specific time in a case. All are some cases that are adjudicated at trial, whether it's guilty, acquitted, or a hung jury. All are some cases where the offender has received treatment, probation, prison, etc. Your team could discuss one case as it moves through the entire system, examining all of these critical juncture points that we've laid out, or your team could perform an overview, like a pilot study over a year or months to determine of all of the cases reported, how many referred to prosecution, how many cases were unfounded, and so on. And really, really focus your learning and decision points on that as well. I just had a question here. It said, what did you mean by the call you mentioned relating to a plea bargain? In Minnesota, it's a pretext call, a way to interview the suspect through the victim. In other parts of the country, it's called a control call and things like that. We know from our work here that can often be a very useful tool and often results in a plea bargain. Not all the time, but we know that that is one successful tactic that law enforcement can use. So we had to get to it, the common sources of rules, and I'm going to turn it over to Caroline Palmer now, our staff attorney, to talk about this.
Thanks, Leah, and this is Caroline Palmer. Thanks for joining us today. I've got the microphone close, but if for some reason you can't hear, just let us know. So just starting with the common sources of rules, it's important to lay the groundwork for case conversations, and so by doing that, we have to talk about the rules. These rules can take different shapes and forms, and they sometimes apply to different people in different ways, but all need to be taken into consideration before moving forward. Usually these rules are the type that cannot be changed, such as a professional ethical obligation or a legal obligation, so we need to find ways to achieve our goals while working within these confines. Laws and case law are, of course, a major consideration. What laws govern confidentiality, professional obligation, and the sharing of information? Next come funder restrictions. What do our grant contracts say about protecting private information? What penalties will be imposed if these contractual terms are broken? Then we have agency policies, the tools we use to protect internal information and how it is shared outside of staff. What is really meant for public consumption? What information, if shared, would destroy the public trust in an agency? Licensure and certification requirements vary among the professions. For example, in Minnesota, some professionals have mandated reporting requirements in certain situations and others do not. Some professionals have privilege, others do not. Different ethical standards and obligations may apply. And finally, underscoring all of these rules is the goal of victim-centeredness. All of our actions are derived from this common understanding and desire to ensure that the system responds in the most effective manner to a victim's needs and concerns. So just to talk a little bit about some of the laws and case law that might apply, and certainly there's probably going to be more as you look on a state-by-state basis, but one key one is the 1963 United States Supreme Court case, Brady versus Maryland. And just to give you a very brief background about this case, under Brady, a prosecutor is required to disclose certain exculpatory evidence to the defense. If the prosecutor withholds the evidence that is material either to guilt or to punishment, then there's a violation of due process. So this is a very serious matter, and we do from time to time hear about these types of cases in the news and know that if the information is withheld, it can completely derail a case. The Brady rule applies to evidence that is favorable or material to the defendant. Exculpatory evidence either opposes the guilt of the defendant or undermines the credibility of a prosecution witness or supports the testimony of a defense witness. Such evidence has a reasonable probability of affecting the outcome of a proceeding. The prosecutor must have actual or constructive possession of the evidence for the Brady rule to apply. Constructive evidence includes evidence in the files of an agency over which the prosecutor has authority. So, for example, that could be a police agency, or it could even be the office where a victim advocate works. So, for example, if a victim advocate works in the office of the prosecutor or the police, then the prosecutor would have possession over that information and an obligation to provide it to the defense if it meets the criteria for turning it over. A prosecutor does not have authority over community-based organizations such as a nonprofit sexual assault advocacy program. However, if there is some sort of tacit agreement in place between the prosecutor and the community agency to, say, investigate a case or prepare a witness for trial, then there may be a relationship that Brady would cover. It's very important to carefully review contracts and any memoranda of agreement that cover these sorts of relationships to make sure that the obligations do not invoke Brady. So, for example, if a victim advocate goes in and sits during a prosecution interview or law enforcement interview just there as a support to the victim, that's not going to be a Brady situation. We're really looking at more of those cooperative agreements to work together with an agency that's outside of the prosecutor's purview. But recognizing this about Brady, it also reminds us that we have to be really careful how information is shared during a case conversation on the team. If a prosecutor learns of possible exculpatory evidence during this conversation, the prosecutor will have an obligation to share that information with the defense. So you need to really constantly be aware of the boundaries of confidentiality and the roles and duties of everyone on the team. In other words, proceed carefully, and you're going to hear that message many more times through this webinar. So we can go on to the next slide. So some other laws that might apply, HIPAA Most medical providers, including SANES, are bound by the Health Insurance Portability and Accountability Act, or HIPAA. HIPAA provides national standards for protecting the privacy of health information. If medical professionals are on your team, it isn't appropriate for that particular professional to share medical information about the patient victim with the other team members. Another key concern is the protection of SANE neutrality and SANE programs in order for their evidence collection expertise to be accepted in court with a minimal level of bias toward the victim or prosecution process. So just keeping this in mind about the specific health privacy laws that are going to apply to the health professionals who are sitting at the table. Title IX and the Clery Act are laws that could affect campus-based teams. Title IX addresses how educational institutions must respond to or report to crime around campus or on campus. Usually this involves some sort of internal judicial process with participation for all parties, some sort of appeals process as well. The Clery Act addresses an educational institution's obligation to disclose statistics for crimes that occur on or around campus. Another campus-related law that's important to note that we didn't include here on the slide is the Family Educational Rights and Privacy Act, or FERPA, and that protects the privacy of student education records. The release of information from these records is governed by consent with some specific exceptions set forth in the regulations. So all of these campus-based laws are attached to federal funding obligations. And again, could be a concern of a campus-based team or if your team is working with a campus in your community. Some other laws that may apply, and as you see here from the slide, they can certainly vary from state to state, so I'm just going to be a bit general in talking about them. Mandated reporting, Data Practices Acts, privileges requirements, they can all apply. These are often governed by statute and have specific mechanisms set forth for when information can be shared and under what circumstances. Some of these laws apply in different ways to different professions and different situations. So it's very important that all of the professionals involved in a case conversation understand their individual obligations under these sorts of laws. I think this is really the kind of conversation you need to have up front so that everybody understands how far and the limits of each person's ability to share information go at the table. Some states have specific provisions for what information can be shared for crime victims under a crime victim rights statute, or maybe in some states you have a constitutional amendment that deals with victim rights. For example, in some states there are specific requirements about how law enforcement can share information with local advocates for cases involving domestic violence, but there may be different rules that apply for how sexual assault case information can be handled. Other distinctions that need to be discussed in this context are between what shall and what may be shared under certain conditions. A team will benefit from discussions of these laws and the policies each agency has developed with regard to them. Again, just as a means of understanding what everybody's role is at the table. And I think it's just very important to constantly be reminded of the reasons why we have these confidentiality rules, why we have data practices rules, and the overall public trust that we all have in the work that we do to protect information and protect victim safety. Another important restriction that we need to be aware of in case conversation is funder restrictions. Often funding sources include restrictions about how information about clients can be used and how often it can be collected and stored. Usually it's collected and given back to a funder in an aggregate form, for example, so you're not giving specific names, you're not giving a person's address, you're just giving general information that will let them know the groups of people who are being served. So some of the several common sources of funding for victim services would include FOCA, FIPSA, Children's Justice Act, and the Tribal Grant Programs, and VAWA. And all of these particular rules for funder restrictions would apply to grantees as well as sub-grantees. And they may not release identifying information about victims who are served with Office of Violence Against Women funds without a written release or disclosure mandated by statute or court order, or a particular consent form completed by the victim. I will talk a little bit more about how information can be released, and I'm going to try and keep the microphone closer to my mouth to see if I can help with the sound. I think really that the final piece to say about funder restrictions is it's just very, very important to familiarize yourself with the fine print on the funder contracts, either on your own or by working with the person in your office who's responsible for federal grant compliance, and just be very clear on what your obligations would be. Just to talk briefly about the elements of a release of information, as you can see here, we've got a list of some of the most important points, including that a release is written, it's specific, it's limited in time, it should state clearly how the information will be shared and what will be shared. It needs to be accompanied by informed consent, signed by a competent adult or a minor who is able to sign for themselves in certain situations, and always, always contain the ability to revoke, but also understand that once information is released, you can't pull it back in either. But you could revoke access to any information in the future. A couple of key things to understand here. A victim who is signing a release must have full understanding of the reasons for the release, the parameters of the release, and the time-limited nature. And I think what's really key here is that person needs to know who will see the information and understand the risks and benefits associated with the release of information. We all can do our very best to control how information is released, but we also know that sometimes information slips up and goes out to the wrong person. Maybe you've faxed some information and it ends up in the wrong person's hands. An email goes to the wrong place, an email gets forwarded. So these are all things you need to be aware of whenever you talk to somebody who's going to sign a consent about how information will be released. Certainly we all make every effort to protect the information and make sure that it doesn't go beyond where it's intended, but people do need to know there are always risks associated with giving out information. And it's just something that comes with the territory, but as we weigh the risks and benefits, sometimes we see that the benefit of getting the information to somebody else is important, that it'll get more access to resources and may lead to a resolution that we couldn't provide on our own. Okay, so talking about other sources of rules, certainly agency policy and protocol might govern certain actions. These are usually set forth by the leadership of an organization, sometimes with the advice of legal counsel. Employees need to be fully trained regarding these policies and protocols, and these policies and protocols should be revisited on a regular basis to make sure that they're up to date, that they're compliant with law, and that they meet any funder requirements. And finally, as mentioned earlier, everyone on the team has different ethical obligations set forth by licensure and certification requirements. These cannot be changed. So for example, a medical provider is bound by HIPAA. An attorney must abide by the rules of professional responsibility and court rules. An advocate may have privilege depending on the state. Some people at the table may also be mandated reporters, and if they hear of a situation that merits of a report, they will need to make that report. So it's important to set forth and understand what sorts of situations will trigger reports and ethical obligations, and everyone at the table needs to respect one another's professional obligations. And really, it's important to note that this may include someone who's not speaking up at all because of privilege and confidentiality obligations to a victim. That person cannot be made to disclose information to the group, shouldn't be put in a position where they are feeling like they're forced to disclose information. They are doing their job by not sharing information at that time. I see that we have a couple of questions here, so before I move along, I saw something about consent or revoking consent, so I just wanted to make sure I addressed that. Okay, so somebody has asked, if a victim decides to revoke, is there any liability if a team member shares info but is not yet aware it's been revoked? Interesting question. I think you'd probably have a conversation about whether that person had a good faith reason for whether or not they had reason not to know. I would want to make sure that any information that was disclosed in this context was very clearly very clearly defined by the victim as information that can be shared, that there hadn't been any revocation. So if I were going to a meeting, for example, and knew that I had been given a release to share information, I would double check and make sure that I still have that information in place and that it hasn't been revoked. If you had a good faith reason why you didn't know that, then I think you'd have an argument against liability. So I think it would really just depend on the situation and the efforts made by the person who has the information, who's sharing the information, to confirm that it's releasable information. Okay, I'm going to turn things back over to Leah.
All right, thank you, Caroline. Just a note, too, that we are getting some chats in that the release of information slide was missing from some people's PowerPoints, and we will be doing a follow-up email reminder, and I will make sure that that slide is out to all of you. So just want to mention that. So before we move on to the focus on the 3 approaches, just really briefly here too, this is something that we've created at SVGI, also rules for being victim-centered rules, you know, in quotations and used lightly. But has your team chosen to define victim-centered is also an informal rule that will dictate how your team chooses to hold case conversations. Case conversations are really bound by your informal and formal rules, and this can be a really great check and balance system for you as you're embarking on this process or have embarked on this process to come back to from time to time. If there's conflict or disagreement, or maybe somebody wants to think about a direction that they can go, your team could revisit rules for being victim-centered and see if it is congruent with what you want to accomplish as a team and how you want victims to be treated during your response that you're building. So finally, we're going to leave the section on rules, and we know that the rules can sometimes seem overwhelming. Again, we don't want to paralyze you from holding these conversations. Our intent here was just to expose you to the what could go wrong, what you need to know, what you need to realize as you're planning this process, and that the benefits of the case conversations can outweigh the risk. It's just really important to be cognizant of that during your team process. And really important to revisit it from time to time, since team members' roles and responsibilities change. You lose team members, you gain team members, and so on. All right, we're going to transition here now and really provide an overview of 3 approaches that we've seen. And our intent here with the webinar is to kind of explain the 3 approaches that we have seen teams utilize and share with you things that they've learned to help make the process go well, to increase the learning, and so on. All 3 of these also have different purposes. Again, so these aren't the only ways to think about doing case conversations, but rather they might help you think about the range of options available, the pros and cons of each, and how your team might create a process that best meets your individual team needs. So the first one that we've identified is system consultation. And the goal that we've seen with teams that utilize this approach is focus on emerging system issues in order to identify those successes, the gaps and problems, solutions or adaptations, strategies to improve the community response to sexual violence. Your team most likely is already doing some sort of system consultation in some form already, and we're just giving it a name. The key word here as we go on explaining this process, it's the system instead of a case. So who is involved? The whole team can be involved in this process. It's usually reactive, a response, either positive or negative to something has already happened, and it can happen at any stage of the response process. Usually we have seen the outcome being that teams can identify what needs to change in protocol, if there is a new emergent training issue or some other issue for team action. The need for case details is really low, and the preparation needed is moderate. So I'm going to give you just a couple examples of system consultations and the features. So for example, one team that we support, a medical professional team member commented how law enforcement officers seem confused about how to pick up evidence at the hospital for transport to storage at the law enforcement facility. The team member had noticed this occurring over and over and over again, and eventually she brought this to the team's attention to try to identify a solution. And through the team discussion, they discovered that their protocol was outdated, and it described features of the hospital that had changed during construction. The team decided that a protocol change needed to happen and also announced an update in a memo to responding law enforcement agencies. So this was information from several cases over time, but it became that noticeable system issue, and no case details were ever shared with the team members during this process. So another example of how a team discussed case-specific problems at a system level is the problem here was that both the victim and the suspect were taken to the emergency department by separate parties, of course, for the forensic and the suspect exam. This clearly created tension, safety, and privacy concerns for everyone involved. And rather than responders bringing those case-specific details to the group, who the nurse was, who the law enforcement officer was, and so on, the responders instead presented it as a system issue by asking the question like, how can we ensure that victims and suspects are not receiving services in the same place at the same time? The team discussed this as something that may not only happen at the hospital, but also at the police station, government building, or courthouse, all those places that the suspect and the victim could have that opportunity to interact. The team changed their protocol to say that whenever possible, suspect forensic exams would be conducted at the jail so as to prevent these sort of encounters from happening. The key thing to this, I think, in presenting this to your team, what we have seen is that if you could figure out a way to pose the problem or what happened during the response in the form of a question, that can really avoid those gotchas and can really lead to some productive problem solving with your team and amongst your team members. So a little bit more detail on how it works, and we've seen elements here to make it work well. So there has to be some preparation beforehand. The team member identifies the system issue. Again, if you can create that culture where the system issue is being identified in the form of a question, that can be really, really productive. They talk with involved parties in advance. So for example, the emergency department with the suspect exam and the medical exam, and let those parties know that they're going to bring this issue to the team so that they can be prepared. And they alert the team leader also ahead of time and prep the team leader to present the system consult issue at their next team meeting. So the presentation that happens then is they explain the system issue, stripped of as many case details as possible. They maintain the confidentiality of the victim throughout. The case details are not shared. And again, review for the victim-centered response. The outcome for this process then can be it assesses for the right fix. We know that there's different fixes for the different problems that you identify. So is this a change in protocol, or is this training, or is this personnel? What needs to happen? And then the team can document the nature of the issue and decision along with the expected next steps. And again, that goes into, if you think about that grid, how to use this process to make that long-lasting system change. And again, just some focus here on language and things like that, how to keep it focused on the system, which we reiterate throughout this. So for example, perhaps there's an advocate who routinely does not respond to the hospital in a timely manner when called. This is a problem specific to that individual advocate. The issue shouldn't, however, be about you need to better supervise your advocates, but again, instead should try to evaluate the problem to a system level like, is there currently a time frame specified in the protocol for advocate response at the hospital? Should we institute one? If there is a time frame already in the protocol, what should we do if that time frame isn't being honored? And for the team leaders out there, another tip to carefully consider this when a particular issue should be discussed by the team Is it best to discuss whether the issue may be fresh but emotional, or is it better to put the issue in the parking lot and to have the discussion about it at some point in the future, perhaps after some tempers have cooled down? And this is the art of being a good team leader and facilitator, and there's really no right or wrong answer, but just for you to consider the timing of this for a system consultation approach. And the second approach that we're going to go into is case review. And this is a much more detailed, in-depth study of a case. It could be from reporting to post-conviction. And the goals here are really to identify the effectiveness of the protocol, the gaps and successes, the flows of the process, victim-centeredness of the intervention, and again, potential areas for early intervention with the offender to stop offending behavior. We're going to get into that a little bit more with the example that I'm going to show you. This model really came out of the idea of the domestic fatality review teams, and we've seen it work with our teams as well. So the case review features who. With this, the whole team can be involved or a subset of the team can be involved. But considerations for roles given who worked on the specific cases should be considered during this. This is, again, a reactive process after the case is closed. Hopefully the outcome is really that deeper system look to the surface patterns, gaps that may not seem immediately obvious, change in policy, training. It can be a really great way to have some really deep, in-depth learning with your team. The need for case details here is high, and the preparation we believe needed on part of teams is high as well. So who? The idea here is to have as many of the actual responders who worked on this case there as possible and part of this process. So for example, one of the teams we support decided to review one particular case of reported intimate partner sexual violence. This case involved a woman and man who had separated, and the man later broke into the victim's home and sexually assaulted her. The case was charged and proceeded throughout the system. Post-conviction, the case was reviewed by the team as a way to review how the protocols had worked. During that review, the team learned that some information known to several responders was not communicated with the defendant's treatment provider. Specifically, the treatment provider thought that the incident was an isolated sexual assault, whereas the victim had reported to other responders, and there was actual documentation that she had obtained protective orders reporting sexual assault in the past prior to the charged incident. So the team had discussions about where the information was lost and discussed ways to prevent this from happening in the future. Were there places that they could have intervened earlier? It was also somewhat surprising to the team, who had initially viewed this particular case as a success because it had been prosecuted, resulted in that conviction, and the offender was enrolled in a treatment program. So this process really changed their perspective and also illuminated many areas where the system had failed or could have done things that may have changed the course of action along the way. Perhaps if the system responded more effectively in the beginning, subsequent acts of violence may have been avoided. We don't know that, but that's our hope with earlier intervention. So the more detailed on how this works for case review. For that preparation, the team selects a closed case for review. Just a note to work with your prosecutor to determine whether the case should be post all appeals as well. In this case, the signed releases from the victim and the offender. The offender for this case, if the team wants the offender treatment probation records. Develop team guidelines for process and have signed agreements about how you're going to respect the confidentiality and the integrity of the process. Develop the witness list and invite. Witness list for this purpose means that all responders who were involved in the case along the way were invited to attend. So then the process is the team hears from actual responders. They talk about what they did, their process as they were doing this case. Team members have the opportunity to ask questions. Again, it's not gotchas, or it's not meant to focus on any individual, but the whole case. Written reports such as law enforcement reports and so on, medical records, are shared, reviewed, tracked, and destroyed, and don't leave the room during this process, but are given to the case review team to provide that full picture, to provide information and background that can be really, really necessary to understanding the system gaps and so on. And the outcome is the learning from individual closed cases to inform system change. And there's one question here: what were the gaps in that case that I talked about with the intimate partner sexual violence? One clear gap was the communication among responders. Some responders had information that other responders didn't. For example, some responders knew that the victim had obtained protective orders regarding sexual assault in the past. Other responders did not have that information. And many members of the team thought this was an isolated incident of violence. And this process clearly showed that the violence in this relationship had started early on, and that the team missed earlier spots to intervene on behalf of this victim. This couple of the really clear gaps. So this team then discussed why were these intervention points missed and what could be done in the future. And a few tips that we've seen. So select that closed case for review. Again, think about what case you could get the most learning from. And then when you're actually going to do this process, then also pay attention to who presents and the roles of the team members during this process. So who presents? Are you going to have a timekeeper, a discussion monitor? That's also can be a very, very important thing to keep members tasked and things like that, and also to keep integrity of the conversation on really wanting to identify gaps and potential solutions rather than gotchas or why didn't you do this or why didn't you do that and so on. You can really focus on what fits and doesn't fit within your protocols, and you can use document and materials and things like that as you're doing that. Plan for ongoing evaluation of case review process. That's really, really important. What are you going to do with this information? First, that you learned from the initial case review process. And if you're going to do more case reviews, and if you decide as a team that this could be a strategy that could fit, how are you going to incorporate this process into the overall work of the team? And why are you going to do it, and what are you hoping that you can accomplish as a result of doing that? And then the third approach that we have seen teams utilize is the active case management. This is the front-end coordination to open cases. In order to, these are generally the goals that teams have identified: attend to the timely and effective processing of cases, ensure that cases are appropriately investigated and prosecuted, catch cases that might otherwise slip through the gaps. And you might, if you look back to that chart of when you could do a review of cases unfounded, what's going to prosecution, and so on. Often teams, when they have embarked on that process, have found significant gaps, and then they will want to try some sort of active case management as the way to mitigate some of the cases slipping through the system. So obviously here, the main difference with this approach to the other two is that these are open cases. Another main difference is that we found is that this coordination is usually a subset of the whole SART team for reasons that we're going to go into here soon. This approach is not yet super common. Some teams are using it, but it's an interesting approach that I think, if handled with care, is potentially very effective and can really have a lot of learning for your team. But I think that the front-end coordination on this really needs to be also attended to. So this approach could be used to brainstorm ways of further and open investigation, provide feedback to law enforcement on what else could be pursued, other witnesses that could maybe be interviewed, and so on. Even if they cases they consider not able to be filed with the county attorney's office. We've seen teams brainstorm ways to make what they consider the toughest cases, the cases that aren't likely to be charged out with prosecution, more chargeable, and to have discussions on that. Some teams have actually used this process to produce a multidisciplinary team and MDT team charging decision. If the prosecutor's office is willing, or just to be used to provide the prosecutor with more information in order to make final charging decisions. Our guess is that it's usually used more as an information gathering and brainstorming, and much less of the actual MDT team charging decision. However, we have seen some teams frame it this way. I think the county attorney or district attorney, whatever they're called in your state, would have legitimate concerns about a process like this and just discuss it. Would those discussions be discoverable? Is there a policy in place to review open cases? How can they say the process is just to review investigative data and so on? How could these discussions interfere with the internal office policy? And will these cases be considered reviewed for charging and affect the county attorney office's numbers? So legitimate concerns. However, we have seen on the flip side also benefits to it, is that the county attorney's office could get an idea on how issues in case sound to others not familiar with the case. What might seem like an insurmountable problem might not be considered. So by others listening to the facts, conversations like this can generate and can maybe move a stalled case and so on. And it can present the victim the charging decision, whether positive or negative, was more legitimate because it was considered by a whole team. So a few features of the active case management, and I know some questions are coming in. We're going to have time. I just want to note about 10 minutes or so at the end to address the questions. So I'm going to hold them for now, but I think we will be able to get to them. So the who is typically that subset of the team. This is the proactive rather than the reactive approach and is related to those open cases. The outcome can be case-specific ideas and actions to improve response in that case. It may or may not be able to be generalized to the larger system context issue, but you also might identify certain trends and commonalities too. The need for case details, obviously, in this case is high, and preparation needed is high. So how this works in practice usually is, and I'm going to give you an example of one team here in Minnesota that had embarked on this process, had a formal agreement in place among team members that outlined their primary goals first and foremost. Why are you doing this? So they didn't start just discussing and working on active case management. They had meetings set up prior to full team meetings, actually, even though the actual review process was a subset. But what do they want to accomplish? And again, that's a way to keep your team focused on task. If this process gets derailed, you can go back to it and say, this is, as a team, this is what we decided we wanted to do. So for example, a primary goal of this team was ensure reported incidents are investigated thoroughly and reviewed for charging in a timely manner. There are significant gaps in their team from when things got from law enforcement to prosecution and prosecuting review for charging. Now there were reasons for that, but they were able to discuss it and so on. But work out in advance those primary goals. In this case, the team members select cases for review and notify the coordinator. So often it's the law enforcement, what I said, those hard cases, those sticky cases. That's just one example. It doesn't have to be those type of cases selecting. The coordinator then usually sent an update to the team 1 week prior to the meeting. And in this case, the law enforcement reports were not shared via email. They were shared at the team meeting where they just took a few minutes to read the law enforcement report first before they started the conversation. Other teams have sent it out via the confidential email as well. Many of these active case management meet on a weekly basis. So those team members select a case for review, usually that difficult case. The team member notifies the active case management coordinator, who in this case is somewhat other than the team leader. Because remember, active case management is a process that requires well-defined roles and a lot of upfront work. So the coordinator may actually be somebody other than the team leader on this part, and it can actually be really helpful. So then the coordinator notifies the active case management subset, remember not the whole team, of the meeting date and the case that will be discussed. And the case is identified by police report number, not victim name. Then during that, the investigating officer usually presents on the case. The police reports are shared, track numbered. They're all given back at the end for shredding. And then usually ideas were generated on how to enhance the investigation, particularly between prosecution and law enforcement. Or in this case, law enforcement had their peers, so they were able to come up and talk about things together. I've tried this, have you tried this, and so on. Only sparse notes are taken and related to follow-up, and again, no case-specific information and things like that. And again, keep in mind that during this process, too, you can create a parking lot of the big picture trend issues kept for the whole team to discuss. So although this is generally a subset, you could go back and, like what we were talking about before, phrasing it in terms of a question, and you can still identify bigger system fixes as a result of this. So just like the other ones, a good conversation needs to happen on the front to figure out how active case management will work. While extremely beneficial, this is the type of case conversation that requires that high amount of coordination and careful monitoring. Like all of the different models, the roles of individuals must be understood. But here, we would like you to give special consideration must be paid to the role of victim advocates and medical professionals. So Caroline earlier led us through that discussion of Brady and the limitations it places on how much victim advocates can bring to this process. And for that reason, what we've seen works best and what we recommend is that advocates could present information about victim reactions in general. Perhaps only have advocates present who did not work directly with the victim in that case that's being discussed, and really respond with questions such as delayed reporting, or why didn't the victim remember, or if there's recanting, maybe there's a safety concern and things like that. So the advocate's role is not there to provide case information, but rather to provide information on victim reactions that can lead to helping understand why the victim did what they did during this case or they didn't. But the goal there is to help, again, with the problem solving of this case. And with SANES, remember that their role is of independent forensic evidence collection. And so similar to how advocates will participate in this process, a representative from the SANE program could participate to comment in general about how the results from a medical forensic exam could be interpreted. But we do not advise having the SANE who worked with the particular victim present to comment on the medical forensic exam as a way to pay special attention to Brady, but also special attention to their role as well. And there's confidentiality agreements should be signed among all participants. And just remember they're not the end-all as well, and that during this process you're going to want the formal agreements, but you're going to want the informal check and balances as well to make sure that your team is upholding the integrity of this process and not discussing too much information and so on, or not blurring the roles between advocates and health professionals. Just a couple more tips. Decide which cases will be discussed. It probably won't be feasible to hold active case management for all cases. Another very important consideration is how will victims be notified of the review? Will you notify victims? Teams must determine how this will be handled. And again, in sharing the rules for victim-centered, this could be a great time for you to have conversations with your team on what it means. And again, then you can go back to this and see if this process that you're designing, developing, if you're already on it, refining, really upholds your mission and your values of a team. How often will the team subset meet? Like what we said, we've seen most of them meeting weekly. How will the cases be presented by law enforcement, by others? And from time to time, revisit the team's purpose statement for this process. Some have even included like the purpose statement on the agendas and things like that for a reminder to team members about why they are doing this and what they hope to accomplish. And finally, really, really think about your documentation. So I gave the example of police reports being numbered and the coordinator of this process ensuring that all reports were given back and shredded and things like that to uphold the confidentiality of the victim in the process, and really just your team as well. So we got through a very brief overview of all three approaches, and just wanted to close here by just kind of giving a review of the three approaches that we've seen and are attempting to define a bit for you in this webinar. So the three approaches are system consultation, case review, and active case management. With system consultation and case review, both are brought to the whole team. Both can result in protocol and system monitoring. Both are reactive, issues that already have arisen that need attention. Usually the system consultation can be a regular part of team meetings. Case review, because of the preparation amount needed and the conversations need to happen, we see them more infrequently, like quarterly or semi-annually. All three are based on MOU relationships. System consultation, again, is specific to that system's response and is not specific to individual case, reactive to emerging issues, positive or negative. And the benefit of the system consultation is immediate focus on emerging issues and solutions. So case review, again, it's reactive, but it does focus on a case and a system. And again, you can decide as a team wherever that case died, you could do a case review on that. And the benefit there is a bird's eye view of the entire process. It can just be a great way of learning and identifying. And usually this too is where emotions have cooled down, especially if it's a case that's gone all the way through the system. As we know, that can take significant months, years. And so the team members often with case review are in a good place to really embark on that shared learning together. The active case management is brought to that select subset of the team. It's cases related to the protocol. Usually it's a regularly weekly type meeting. Again, based on the MOU. We hope it focuses on the case, but also gives teams an opportunity to identify what changes need to be made in the system or what's going well in the system as well, and to share that as well. And this is a case that's proactive. A benefit is ensure cases proceed in timely and effective fashion. But again, it's high preparation, high conversation, high attention to all those rules that Caroline went over in order to really design a process that results in a team reaching their goals with this process. So finally, just to kind of summarize, considerations before you begin. Why do you want to discuss these cases? Start there. Where are those learning points? How long has your team been together? Use that readiness assessment tool. Are you ready to be doing this, or do you need to first talk about how you're going to team together, how you're going to hold each other accountable and things like that? Do you need to lay a little bit more foundation? Who's on your team? Have those conversations about the rules of policies around sharing information, what the different agencies and disciplines are governed by, both formal and informal as well. What is the status of the cases we want to review? How are you going to use the information to share and record? Again, you're hopefully designing a process and taking the time to do that and do it right. It can result in great information. So what are you going to do with that information? And have conversations about that. How do you ensure that victim privacy and safety? And again, how do you ensure that your processes meet the goals? So revisit that from time to time. Make your goals visible with your team members. Don't let it get embedded so that it can always be on the forefront of team members' minds. Look and listen for. What does a good response look like? What is a good response within one agency or discipline? What is a good response across multiple agencies or the whole system? How consistently are we doing it with these cases? And is your team adapting your response when the circumstances require it, or are you just kind of keeping with the status quo? A few additional resources. I know there were some questions on proper elements of release of information. The Safety Net Project has information on proper releases that you can go to their website, as well as the Victims' Rights Law Center, and our website and information is there as well that we hope you can come and visit. And finally, we announce, save the date for all you team leaders and coordinators, or if you're a state level team leader who's working to support SART teams across the spectrum in your state. We are going to have our second annual National Institute, thanks to continued support from the Office on Violence Against Women. The dates are October 29th through the 31st. You can see the slide's a little bit hard to read that. It's a 2.5-day institute, so the 29th and 30th will be full days, with the 31st ending at 12 or 12:30. This is your chance for team leaders to come together, to network, to share, to learn new skills, to learn new content, and also really thinking about how to move your team forward for the next year or so. So that finishes this part of the presentation, and I'm going to take some time to answer your questions. And if you have more questions, feel free to send them through the chat as well. And even if we don't get to all your questions on the webinar, because we do have quite a high volume, I want you to know that they will inform our future work with this, so we appreciate the questions. So the question, if your team is new, is case review even helpful to making changes? That's a great question. So my opinion with working with newer teams is that I would recommend really laying the foundation of your team first. How are you going to organize further work? What are your goals? What are the roles and responsibilities of team members? And what are your goals outside of the case conversation process as well? Is it to develop a training curriculum? Is it to develop protocols? Is it to start a SAME program, and so on? Those can vary. So I encourage that first. And then with new teams, I think that system consult is a great way to start because, again, it can build that trust and rapport with team members, but you can really dig into some great juicy details about what needs to change in the system. And then that also gives team members that opportunity to learn the nuances of all the privacy considerations, the rules, the Brady's, the roles and responsibility before embarking on a full-fledged case review process.
Hi, this is Caroline. I'm just going to address one question that came through earlier, and somebody wanted to know if a teen victim can consent independently to advocacy services, can they also consent to independently release their info? And what I would suggest in that case is to take a look at your state laws. It may be the case that they can. It would depend on their circumstances and the type of case. Are they an independent minor? Are they emancipated? Are they on their own? But there may also be state laws that allow youth to access certain services without a parent's consent. So for example, in Minnesota, we have minors consent to health care laws, and a minor is able to access certain health care services, mental health, other types of services without a parent's consent, and then would be able to consent to release of information too. So what I would suggest is to just take a close look at your various state laws that affect youth access to services, and it may well be the case that they are able to consent to release information in certain situations depending on their status and depending on the types of services they receive.
Great. And here's a couple other questions. Are these the only 3 ways for teams to discuss cases? No. What we attempted in this webinar and through our TA on this issue is to kind of catalog the range of responses and the landscape that we've seen teams utilize and share their successes, their strategies, and also their lessons learned. And why have we chosen these 3? It's really to highlight the key aspects that need to be considered for these 3, that we think that teams, if they consider those 3 aspects and also the considerations with each of them, can really pick a process that will be really conducive to their overall team approach and what they want to accomplish. All right, here's another one. Would it be important to review and present what is working? We ask our teams to do both what's working and what needs to be improved. Absolutely. You know, I probably didn't highlight that enough during the webinar, but we hope that this is the opportunity to share gaps and what needs to change. But also there's just a lot of great work going on in many communities throughout the country, and absolutely share what is working. We all don't have enough resources. I'm sure you're all working way too many hours and so on, and it's great to also hear and know how what you're doing is making a difference. And oftentimes we don't know. So this process can be a really great way to do that. And another question for the active case management. So these initial investigations would need to be very broad or general. If I understand that correctly, the level of detail that is shared with active case management can be very detailed as far as investigation, from the police report to the witnesses to even techniques that law enforcement is considering to enhance the effectiveness of the investigation. So generally with the active case management with law enforcement, it's much more detailed information, much more in-depth information. And again, the reason why to really set up that process beforehand.
There was a question about team members coming in and signing a confidentiality form at every case review meeting as a reminder that information shared should stay in the room, which is a great place to start. And then the other part of the question was, should we still be getting signed releases from victims when we discuss specific cases, and what if it's not possible to get a release, let's say the victim is unable to be reached? And I think really what this goes back to is looking at the different approaches that Leah laid out here in the webinar about how you might be discussing a case. Are you looking at just making a broader system change, or are you actually talking about a specific case after it's over and done with, or is it an active, ongoing case? And I think those different situations would have me respond in a different way about whether or not you need signed releases. If you're looking to have a more general discussion about policy and protocol, no, I don't think you need a signed release. If you're going to evaluate a case after the fact, if you can get a signed release, I think that would be the very best way to go. If you cannot locate the victim, maybe you're going to be limited in some of the information you can use. You might need to just stick more to the public information that everybody has access to versus information that you might be able to obtain from a release otherwise. So I think really what it comes down to is identifying your goal for the discussion and the format you're going to use for the discussion and how specific you're going to get into information, and then that's where your questions about released information come into play. And I think the other thing you need to be aware about is timing is so important here. If you're talking about an active case and you're releasing some information, that could then become part of the case potentially. And so you really need to, I think, to sit back and think strategically about how you're using the information, why you want that information, and when you need that information. And then if you are going to want to release, then there needs to be a conversation with the victim about the pros and cons of releasing that information.
Thanks, Caroline. We're going to just take one more question, and we want to be respectful of your time. One question is, how would you handle a situation in which the prosecutor, in this case the U.S. Attorney's Office, is unwilling to share information for the purpose of a case review? I would recommend using that tool that's attached to this webinar as a basis to have your conversations, because it can really help to clarify the goals, the outcomes, the shared missions, maybe what you disagree on as well. And maybe right now case review wouldn't be appropriate after you go through that process. Maybe you would find out that it is appropriate, but you're going to have all the information on the table, and maybe your team would want to start with a system consult and start the learning there, and then progress on to something. You know, as circumstances change or as you're learning more about this process, what works for your team and so on. So we want to thank you from the Sexual Violence Justice Institute for being part of this webinar. Feel free to contact us if you have questions. We did not get to all your questions today. We are developing some resources for this topic and have additional things that we can perhaps share with you. So again, thank you. And right now we'll close out the webinar. Thank you.
Thank you. Please stand by.